What is probate in New Jersey? Probate is a legal process many New Jersey families encounter after a loved one passes away. Probate in New Jersey is the court-supervised process used to validate a will, pay debts, and distribute assets to beneficiaries. In most cases, a will cannot be admitted to probate until at least 10 days after the person's death. Probate is typically handled through the surrogate's court in the county where the deceased person lived. The process begins when the executor named in the will files required documents with the surrogate's court. If there is no will, or the named executor cannot serve, the court appoints an administrator to manage the estate. The executor must submit a certified death certificate, the original will, and an application for probate. Once the court validates the will, it issues letters testamentary granting legal authority to act on behalf of the estate. Without these letters, the executor cannot access estate assets or make distributions. After appointment, the executor must notify beneficiaries and certain heirs within 60 days of probate. The executor is responsible for identifying and securing estate assets during the probate process. This includes determining date of death values and obtaining appraisals when necessary. Before assets can be distributed, all valid debts and expenses must be paid. These obligations may include final bills, funeral costs, and outstanding loans. The executor must also handle required tax filings, including final income tax returns. Under New Jersey law, creditors generally have up to 9 months to present claims against the estate. Only after debts and taxes are resolved can assets be distributed to beneficiaries. Not all assets must go through probate in New Jersey. Probate assets are those owned solely by the deceased without joint ownership or beneficiary designations. Assets such as jointly owned property with rights of survivorship typically pass directly to the surviving owner. Retirement accounts, life insurance policies, and payable on death accounts usually avoid probate. Property held in a properly funded revocable living trust also bypasses probate entirely. Whether probate is required depends more on how assets are titled than on the total value of the estate. New Jersey offers simplified small estate procedures for certain estates without a will. If there is a surviving spouse or partner and the estate is $50,000 or less, a small estate affidavit may apply. If there is no surviving spouse or partner, the threshold for a small estate affidavit is $20,000 or less. These simplified procedures are not available when a valid will exists. When someone dies without a will, New Jersey intestate succession law determines who inherits the estate. In those cases, the court appoints an administrator rather than an executor. The executor or administrator has a fiduciary duty to act in the best interests of the estate and beneficiaries. Failing to meet these duties can result in personal liability. Probate timelines vary depending on estate size, asset complexity, taxes, and disputes. Some estates close within several months, while others take a year or longer. Working with a knowledgeable lawyer can help executors understand their responsibilities and avoid costly delays. An experienced attorney can assist with court filings, tax issues, and asset distribution throughout probate. Choosing the right law firm provides guidance and clarity during a complex legal process. For families navigating probate in New Jersey, support from a probate lawyer can make the process more manageable. The Matus Law Group helps executors and families understand New Jersey probate law and their legal obligations. You can contact the Matus Law Group at 125 Half Mile Road No. 201A, Red Bank, New Jersey, 07701, United States, or call 732-785-4453 to discuss probate matters with their law firm.